Chief Val Daniels here with another criminal law lesson for Dr. Field's classes. Today I will be discussing California Penal Code Section 518, extortion, which is also commonly called blackmail. It occurs when you threaten another person in order to obtain money or anything of value. The types of threats and things of value are explained in Jury Instructions, Cal Crim. 1830, extortion by threat or force. To prove this crime, you must show that 1. The defendant threatened to unlawfully injure or used force against another person or a third person, or the property of another person or a third person, or the defendant threatened to accuse another person or that person's relative or family member of a crime, or the defendant threatened to expose a secret about another person or that person's relative or family member, or to expose or connect them with a disgrace or crime or deformity. And 2. When making the threat or using force, the defendant intended to use that fear or force to obtain the other person's consent to give the defendant money or property, or to give the defendant anything of value that involves sexual conduct or an image of an intimate body part, or to do an official act. 3. As a result of the threat or use of force, the other person consented to give the defendant money or property, or to give the defendant anything of value that involves sexual conduct or an image of an intimate body part, or to do an official act. And 4. As a result of the threat or use of force, the other person then gave the defendant money or property, or gave the defendant anything of value that involves sexual conduct or an image of an intimate body part, or did an official act. The term consent has a special meaning in this statute. Consent for extortion can be coerced or unwilling, as long as it is given as a result of the wrongful use of force or fear. The threat of use of force must be the controlling reason that the other person consented. If the person consented because of some other controlling reason, the defendant is not guilty of extortion. Threatening to do something that a person has a legal right to do is not a threat to commit an unlawful injury. The threat may involve harm to be inflicted by the defendant or by someone else. An official act is an act that a person does in his or her official capacity, using the authority of his or her public office. For the purposes of this law, a secret is a fact that 1. Is unknown to the general public or to someone who might be interested in knowing the fact, and 2. Harms the threatened person's reputation or other interests so greatly that he or she would be likely to give the defendant money or property, or give the defendant anything of value that involves sexual conduct or an image of an intimate body part, or do an official act to prevent the fact from being revealed. An example of extortion would be threatening to expose the mayor's extramarital affair if they do not vote yes on a certain proposal before the city council. A defendant can challenge extortion charges by claiming that they did not use force or make a threat, or the victim did not perform the act that they consented to do. Chief Val Daniels, and that was your lesson on the crime of California Penal Code Section 518, extortion.